afternoon, everyone, and thank you for joining us today for HR compliance considerations for the new year. I'm Ashley Smart, Director of People and HR Services here at Dominion Payroll, and we're excited to have you with us as we kick off a new year full of evolving compliance requirements and opportunities to really strengthen your HR practices. A new year often brings lots of regulatory updates, shifting expectations, and questions about what employers should be prioritizing. Today's session is designed to help you cut through the noise and focus on what really matters most as you plan for the year ahead. We are thrilled to be joined by Susan Levi, CEO of Jinji HR. Susan brings extensive experience helping organizations navigate HR compliance, and she'll be walking us through key regulatory updates, emerging trends, and common compliance pitfalls to be mindful of as we move into 2026. But before we get started, just a few housekeeping notes. Today's webinar is being recorded, and all registrants will receive a copy of the recording and slides following the session. Just wanted to give you a heads up. We may go about 15 minutes beyond our scheduled end time to ensure that we fully cover the compliance updates that you need to stay current for your new year. We completely understand if you have to jump off early, but rest assured you'll be able to catch everything that you may miss when the recording is sent out afterwards. If you have any questions, feel free to go and drop them into the Q&A chat, and we'll address as many as we can at the end. With that, Susan, I'll turn it over to you.
Thanks so much, Ashley. Hi, everyone. Thank you for joining today. So excited to be here. As Ashley mentioned, we'll be going over HR compliance considerations for the new year. So to kick things off, a new year does bring new compliance challenges and opportunities to strengthen your HR strategy. And employers are entering 2026 facing ongoing state and local employment law changes, increased enforcement activity, and higher expectations around compliance practices, particularly for multi-state and remote workforces. So today we're going to focus on essential employment law updates for 2026, key nationwide trends that are impacting employers, common compliance pitfalls, and practical steps that HR and leadership teams should take now. To just highlight, there were quite a few minimum wage updates. A dozen states raised their minimum wage for January 1st, 2026, and there's many states and counties that have higher local rates, some of which changed January of this year. Some of the local changes happened July 1st, so they just happened mid last year and will happen mid this year again. As a reminder, you must always pay whatever the highest applicable rate is, which may be a local ordinance, not the state minimum wage. But here we highlighted what some of the state minimum wage changes are so that you have it for reference. And employers must pay based on where the employee work location is. So not where your headquarters are or your office is. If your office is in one local minimum wage, but the employee is working remote from a different local minimum wage, you will need to go by that. In addition to minimum wage updates, there's been some changes for exempt salary threshold. So I know that with the previous administration, there was a lot of talk about potentially increasing the minimum salary, but that has not changed from a federal standpoint. So it's still around $35,000 annually, but many states have higher thresholds. So the states that increased thresholds for January 1st of this year include California, a little bit over 70,000, Colorado over 57,000, Maine over 45,000, and then New York, it depends on which county. So these 4 counties are over 66,000, while the remainder of New York State is a little over 62,000. And then Washington at the highest is over 80,000. So keep in mind, if you have someone that is exempt, they have to be at the salary threshold for where they are working. Just a little refresher on non-exempt versus exempt, because we do continue to see a lot of compliance issues with classifications. So exempt versus non-exempt falls under the FLSA, the Fair Labor Standards Act, which is a federal law, and it determines how someone can be classified, and it's more than just meeting that salary threshold. Misclassification is one of the most common compliance violations, and FLSA sets a baseline, but certain states have stricter requirements. So you want to make sure that wherever the employee is working, you're following the requirements for that state. If someone is misclassified, it can be a snowball effect. So often if someone's misclassified as an exempt salary paid employee and they should have been non-exempt, the employer probably doesn't have any time records, and the onus of time records falls on the employer. So without those time records, an employee can say, well, I worked 5 hours of overtime every single week since you hired me, and the employer has no record to show otherwise. So in that case, you have situations where the employee receives back pay, overtime premiums, penalties. There can be interest, the attorney fees for the employee, the attorney fees for the employer, and it just becomes a really costly error. So it's really important that you're looking at your classifications, looking at the duties test. So to talk a little bit about duties, just for a quick highlight reminder, there's a couple different classifications for someone to be considered an exempt worker. So the first is an executive exemption. And for an executive exemption, they need to be paid on a salary basis, which we were just talking about. And their primary duty must be management of the organization or of a department in the organization. They must regularly direct 2 or more full-time employees or their equivalents. And they have to have the authority to hire, fire, or make meaningful recommendations that are given weight in employment decisions. So if someone is just managing, but they don't really have any decision making, they have to go to someone else for approval for any decision that they're making in that employment decision, they wouldn't be considered an executive exemption. Similarly, sometimes we find someone who's only supervising one person, they wouldn't meet that 2 full-time employee threshold. There's also an administrative exemption, which is the one that a lot of employers try to group employees under. So similarly, they need to be paid on that salary basis at the threshold, and they must perform office or non-manual work. Their work must relate to the management or general business operations, and they must exercise discretion and independent judgments on matters of significance. So this piece is very important. It needs to be something that's going to affect the business's bottom line. So the ability to decide, are we ordering black or blue pens, is not significant. They are someone who's able to enter into vendor agreements. They're someone who is making decisions on things that are going to largely impact the business. One misclassification we'll see a lot is people being classified under this when they are really just following a set of procedures. So someone following a set of like AR, AP, accounting procedures, even though, yes, they are sending invoices or paying invoices, because they're just following procedures that someone else created in the organization, there's no real decision making. The decision making is, I've followed these steps, and if the invoice has been received and the invoice has been approved, therefore I can pay it, even though they get to be the one that pays it. That's not independent judgment. So roles like processing payroll often are not coordinator level roles. Anything that's just following a laid out set steps would not meet the threshold for administrative exemption. And then a few other exemptions: learned professionals. So these are people that have advanced specialized knowledge. They've taken prolonged courses of education. They have degrees, licenses. This might be someone like an attorney, CPA, engineer. Creative professionals. So they are engaging in a duty that requires originality, creativity. This could be art directors, writers. Computer professionals. This is a highly skilled computer system or software role. It is not a help desk role. So similar to the administrative exemption, help desk roles are following a set of procedures. They are not developing, creating that. So they would not qualify. Just to note, all three of these need to meet the salary requirements, but computer professionals in some states do have higher thresholds. For instance, California, it's over 122,000, a little bit more than that. So making sure that you're following state-specific requirements is important. And then lastly, outside sales, this one comes up quite a bit. So primary duty must be making sales, and they must work away from the employer's place of business. Working remote from your home would be the same as working at an employer's place of business. This person should be out and about, meeting with prospects, meeting with clients, knocking on doors, and they should be engaging in that 51% or more of their time. Outside sales does not have the salary threshold that's required, but if someone is inside sales, so the majority of the time if they're soliciting on the internet, sending emails, making phone calls, and they're not actually out and about, they would be inside sales. They would need to be paid on an hourly basis. They would be entitled to overtime. So it's really important to differentiate if an employee is inside or outside sales so that you pay them properly. Tying into pay, there have been some updates with pay transparency laws. So 36 jurisdictions have some type of wage transparency protection. And 6 states implemented these updates in 2025, which are listed here. And not all wage transparency laws work the same. So some are protections that employers can't prohibit workers from discussing wages, which have already been protections under the NLRA. But in addition, some have disclosures that are required where employers must provide some type of wage information to employees and applicants. So that may include having wage information in a job post, providing wage ranges for positions upon request by applicants or by employees. One example of an update for 2026, California already had pay transparency requirements in place. However, January 1st of this year, they've clarified that the pay scale must be an actually good faith estimate of the range. So what they were seeing with their prior legislation was that employers were putting pay ranges of 10,000 to 500,000, which we all know there's not going to be the same role that is paying such a varied range. And so now they're saying you have to actually put a good faith estimate. So if you expect to pay 80 to 85, it should say 80 to 85 and not 10,000 to $500,000. Wages would be all forms of pay that include bonuses, stock options, benefits. And California also says that you have to keep the job titles and wage history for 3 years. One thing that's really important to remember, particularly because so many employers are continuing to hire throughout the country, expand the remote workforce, is when you're posting a job, if you are posting it and it can be open to candidates anywhere in the country, you are expected to follow any state provisions around this. So if candidates from California can apply, then you must follow the California pay transparency laws. If candidates from Colorado can apply, similarly, they have job posting requirements with wages. So if you're opening up the field to candidates, you have to make sure that your job postings are meeting those state requirements, even if your headquarters is somewhere that doesn't require this. We're also continuing to see updates in pay stub requirements. So states are expanding the content requirements, and payroll systems must reflect state-specific rules. One of the great things with Dominion Payroll is that they're going to make sure that your pay stubs have all of the compliant pieces that are required by different states. Effective 2025, Ohio added quite a few requirements for their pay stubs. 2026, this one's pretty interesting. So Oregon now says upon hire, all new hires must receive a disclosure that lists out all of the different pay rates and codes that would be used on a pay stub and what those codes mean. And that disclosure needs to be updated annually. So we haven't seen that with a lot of states yet, but I bet it will be coming more and more. So making sure that you've gone through all of your pay codes if you have any employees there, and that you're incorporating that into your onboarding documents so that employees have that disclosure. And then, of course, some states like California, Colorado require sick leave hours or PTO if used in lieu of sick time to be listed on the pay stub. And as a reminder, even if you're with a big, well-known payroll provider, sometimes you have to click a box or tell the payroll provider that you want that displayed on your paycheck. So don't assume that you're compliant just because you're with a certain payroll provider. Making sure, taking a look at that pay stub if it's a requirement, making sure that that is all on there. Another question that comes up sometimes is digital pay stubs. So generally they are acceptable if employees can access it on the day, payday, and they have the ability to retain it. So view it, print it, save it. Some states require that the employees have the ability to opt out. So if you implement digital only, they're allowed to say, I would still like a paper copy, and you would have to provide that paper copy. And one state, Hawaii, has an opt-in. So in order to go paperless in Hawaii, employees have to opt in that they want paperless. Non-compete agreements. This was being talked about a lot. There was a potential federal ban that was then overruled, but we're still continuing to see heightened restrictions and bans from more states. So states that have a complete ban on employment non-agreements are California, Minnesota, North Dakota, Nebraska, and Oklahoma. 2026, Texas has placed restrictions on non-competes for physicians unless the non-compete has specific limitations, things like geographical restrictions, things like buyout options. So that is very important to keep in mind. And some states allow non-competes, but only for highly compensated employees. So employees who exceed a certain salary threshold, and it's prohibited if someone is working below that threshold. How the threshold is determined varies based on the state. It could be a consumer price index, federal poverty level, or the state's minimum wage. And some of the states did increase their threshold for 2026 for what they consider to be a highly compensated employee who can have a non-compete. So it's really important that you're taking a look at sometimes non-competes are incorporated into your employment agreement. You might not even realize. Sometimes we'll have employers ask us, well, can we still give the non-compete? So that kind of as like a scare tactic. We know that it's not enforceable. We're never going to go after anyone for it, but we want employees to abide by it. The answer is no. So most of the states that have a ban on non-competes, when that ban went into effect, there was a requirement to tell all current and former employees of a certain length of time that the non-compete was no longer in effect. And often those states have some kind of penalty for continuing to provide a non-compete when it's not enforceable or allowed. So make sure that you're not providing this to employees that are in states that do not allow it, or if the employee is below the dollar threshold that allows for it. Arbitration agreements are another area that we're seeing common pitfalls. So placing arbitration agreements inside of handbooks, not a good idea. So often handbooks say this is not a contract. So placing an arbitration agreement inside of a handbook, you're either saying this is a contract because I'm putting an agreement in the handbook, or the arbitration agreement won't hold up because you're placing it inside of a non-contract. So arbitration agreements should be separate from the handbook. They should be separate from an employment packet. So it shouldn't be, there have been court cases where arbitration agreements have been in a long stack of employment documents and it's given to someone and they need to complete it in their first 30 minutes of employment on their first day, that's considered rushing the employee, obscuring the document, and then the arbitration agreement is subsequently thrown out and cannot be applied in any kind of claim. So it's important that it's a standalone document, that it's properly executed and acknowledged, that your arbitration agreements are state specific. And you want to take advantage, if you're going to have an arbitration agreement, to include that class or collective action waiver. One of the best things about an arbitration agreement is preventing those class actions. So take a look at your arbitration agreements, make sure that they're not hidden in other documents, that they're not a paragraph in your offer letter, that they're not a paragraph in your handbook, that they're standalone. So tying into properly executed and acknowledged, taking a look at your e-signature process. So electronic signatures have the same legal effect as a handwritten signature. There's a couple federal laws that this falls under, and many state laws have their own state-specific guidelines. So making sure that your e-signature is going to meet whatever state requirements have. So some states require that the e-signature, the employee has their own username and password, and that the employee logs into a protected system to sign the agreements. So logging into your payroll provider, they have their own credentials. They have to log in through those credentials to access the document. And then some states do require that the signed agreement has the employee name, the date and time of signing, and the IP address. The burden of proof is on the employer to show who signed the document, not just that the signature happened. And some systems, even common systems, might not meet certain state thresholds due to not retaining the verification long enough or failing to properly verify altogether. One system that sometimes we get asked about is Adobe Sign. We've gotten a couple different legal opinions on this. Because they use a transaction ID that does not show the IP address, and that is only retained for 25 months. There's some court cases where it was still accepted, even in these more strict states. Some attorneys are kind of recommending staying away from Adobe Sign just because why use something that could potentially be called into question when there are other systems that can be more thorough for your e-signatures. Other updates we've seen this year: continued involvement of the paid and family leave laws. So as of January of this year, 13 states and Washington, D.C. have paid family and medical leave programs. Payroll contributions to these programs are mandatory. And we're seeing an expansion of leave reasons and durations in multiple states. So Colorado extended the duration up to 12 additional weeks for a parent who has a child receiving inpatient care at a NICU. Rhode Island has expanded their temporary caregiver insurance from 7 weeks to 8 weeks. And Washington is expanding job protections for smaller employers and employees who have worked less time, providing benefits in more circumstances. Minnesota has a paid leave benefits beginning this year, as does Delaware, and Maine will happen a little bit later in this year. So again, keeping that in mind, if you have employees in multiple states, the best bet is to create a handbook that's a multi-state handbook and then state-specific addendums so that you're outlining all of these different policies based on the states that the employees are located in. Similarly, we see lots of different paid sick leaves, and sometimes it can be quite confusing. Every state that has paid sick leave might be different from one to another. And even in those states, there might be local municipalities that have a different sick leave that's different from the state. Sometimes we are pulling up borders to figure out, well, is this employee in this city or are they in this unincorporated part of this county, to determine which sick leave they might receive. So if you have people that are working locations other than your main offices or headquarters, you're going to want to make sure that you are compliant with those sick leave requirements. Over the last 2 years, we're seeing many expanded accrual rates and different permitted use reasons. Local ordinances often exceed state laws and must be followed. And we're really seeing a struggle. A lot of times employers say, well, I just want to give everyone the same thing. And it becomes increasingly difficult. Some states allow for a combined PTO policy, which is permitted in those states as long as you're providing the minimum sick time requirements. So if you have to accrue 1 hour for every 30 hours worked of sick time, you would need to do the same for PTO. And you need to allow the leave to the PTO to be used for all of the same reasons as the sick time. States that consider vacation or PTO to be wages that have to be paid out, even if your PTO is being used for sick time, if you're considering it PTO that has additional uses other than sick, you may have to pay that out depending on which state it's in. Additional consideration for that combined policy is when someone can use PTO for sick time, that means that they can use all of that amount for calling out sick for any qualified sick reason. So sometimes when employers give more PTO than the normal sick time, we'll hear frustrations like they've called out 15 days this year. But if you will provide that flexibility for that combined policy, you have to allow them to use it in that manner. Real quick, meal and rest break compliance. This really varies based on state or local municipality, lengths of shifts that employees are working, but we continue to see violations in certain states for missed or late meals, invalid waivers, or employees not clocking in and out for meal breaks, and then it's resulting in penalties. So if you're in states that require this, make sure, take a look at your waivers, make sure that everything is up to date in your system. Employees are clocking in and or out and in for their meal breaks. Remote work and multi-state law. Remote work has permanently changed employer and compliance obligations. Employment laws apply based on where the employee physically works, and one remote employee can trigger state-specific requirements. So for example, the Colorado paid family leave that we were talking about, that's for one or more employees in that state. So if you hire one employee in Colorado, you now need to make sure that you have those disclosures in your handbook, you're giving the appropriate notices, and they would be entitled to the amount of time off if they have a qualifying reason. This impacts wages, leaves, taxes, postings, notices. So hire one person in one state, make sure you're giving them all the new onboarding requirements, all of the posting requirements, and certain states require E-Verify. So determining if employees in any of your states need to complete an E-Verify. And the location of employees, it's essential to know where they're working. So if you have fully remote employees, we typically recommend that you have a provision in their remote work policy that they must receive approval in order to work anywhere outside of their primary residence. They must receive that approval in writing from a manager or HR. That prevents you from finding out that you had an employee work in California for 3 months over the summer and suddenly you were out of compliance because you weren't following the California laws. So making sure you know where they're working and that they're getting approval prior to working somewhere else. Little bit on AI regulation. AI, automated decision-making technology, includes algorithms and tools that analyze data to predict performance, suitability, or outcomes in employment decisions. AI use in the workplace continues to grow, prompting legislators to adopt new rules and restrictions. And for 2026, we saw a few updates with this. So Illinois has AI is regulated under Human Rights Act, and employers must notify employees when AI is used, and AI cannot result in any discrimination based on protected traits. Colorado AI Act, effective June of this year, requires impact assessments, risk management programs, disclosure to employees and Attorney General. And California prohibits employers from using AI tools in a way that results in discrimination under the Fair Employment and Housing Act. It's really important when you're looking at AI tools that you are ensuring that they're not going to be discriminatory. So I know AI in recruiting is really popular, reviewing resumes. There have been quite a few studies that some of those tools engage in discrimination, whether it's national origin, race, gender, just based on judging an applicant's name. So the issue will fall on the employer. So you won't be able to say, well, it's the tool's fault. You implemented the tool. So you want to make sure that the tool you are using is not going to be engaging in any kind of discriminatory decision making. And so continuing to audit, check, make sure, do some actual human checks to make sure that that is not happening. Make sure that the data is going to remain confidential. If you're using it in your onboarding workflow, if it's having access to even access to employee emails and phone numbers are considered confidential, private protected information in many states. So ensuring that you're picking an AI that is going to keep that data confidential is really important. We've had some updates to protected characteristics. So several states have added a new list of new characteristics that are protected in the past year. You want to make sure that you're keeping your equal employment opportunity statements and discrimination policies up to date. And a reminder, you generally can't take adverse action against employees or applicants based on protected characteristics. So some recent additions: Colorado added gender expression, Delaware added military status, Minneapolis added justice impact status like criminal history, housing status, height, weight. Connecticut added victims of sexual assault and human trafficking. Illinois added zip codes, and California added the intersection of multiple protected characteristics or the perception that an individual has or is associated with someone who has such characteristics. So again, take a look at those policies, make sure that you are including all of them and updating them for the new year. A reminder on immigration compliance best practices. I'm sure we all see the news. There continues to be audits and reviews of I-9s. So it's important that you are looking at your I-9 forms to ensure compliance with federal employment verification requirements. Verify that the documentation is complete, accurate, and up to date. Penalties for I-9. If you have an inaccurate I-9, it's not a penalty per form, it's a penalty per section of the form. So making sure that everything on the form that needs to be complete is complete. If you find that you're missing I-9s or that there are errors on I-9s, do not backdate them, but instead complete them with today's date. Make sure the file is complete and accurate. As a reminder, some cities, states, counties have restrictions on cooperating with ICE or conducting audits. So if that is coming up in your workplace, you want to consult legal counsel for state-specific restrictions on ICE compliance. And make sure that you understand what your jurisdiction-specific rules are. I know California just implemented something this year where you have to issue a Know Your Rights packet to the employees about their rights with any kind of enforcement that comes on site, and collect emergency contact information if someone wants an emergency contact to be contacted should they be arrested or detained during work hours. So knowing what's going on in different jurisdictions to make sure that you're collecting the right information and following that. And then also confirming E-Verify participation. So E-Verify is required in some states and also is the only way to complete virtual I-9 documentation review. So we had a little bit of flexibility during the COVID times. That's been taken away. So I-9 documentation must be a tactile review, a physical review. If you are doing a virtual review, you have to be enrolled in E-Verify. You must submit the employee through E-Verify, and then you would do a virtual call where you can review those documents virtually, in addition to getting a copy of them sent to you. So making sure that you're following that, particularly as employers are continuing to hire employees in multiple states that you might not have a headquarters in. Handbooks are really important. If you don't have one, I strongly recommend that you implement one. It establishes, documents company rules, expectations, provides that consistent framework for discipline and enforcement. It demonstrates compliance with required laws and policies and outlines employees' rights, benefits, leave entitlements. And it's a great reference point for managers and employees. And it helps reduce risk when policies align with actual practices. So if you don't have one, I recommend it. If you haven't looked at it or updated it in a while, I recommend that you look at it, make sure that it's up to date, that it actually reflects what you're doing in your current process, and that all of the compliance is up to date. So just a quick checklist, what you should do now, you want to review your policies and handbook, ensure that you have proper acknowledgments on everything, audit your wage and hour information for exempt, non-exempt classifications and thresholds, confirm remote work approval, tracking, location-based compliance process, confirm any kind of required notices, posters, training obligations for different states. Different states have different harassment prevention training requirements, Connecticut, California, quite a few of them. Review your non-competes and arbitration agreements. Make sure that if you're using non-competes that it's permitted in those states, that your arbitration agreements are a separate document. Look at your time off policies. Make sure that your leaves are accurate. Review your AI usage, and then of course, audit your I-9s. Jinji HR supports many employers. Some have no internal HR, some have internal HR that we are supplementing. Here's just a broad range of some of the services that we offer. If you're interested in more, please reach out, email, check out our website. We'd love to hear from you. And with that, I know we've already run a little bit over, but if you have any questions, I'm happy to answer them. You're welcome to message them into the Q&A.
We did get some questions for you, so I'll go through those and then you can take a stab at them. First is, should all non-exempt employees be paid hourly? And is it okay to have non-exempt paid a salary but receive overtime over 40 hours, specifically in Virginia?
Great question. So I feel like this one's come up a lot in the past month for me. Non-exempt does not need to be paid hourly, but they are entitled to overtime. So sometimes we see non-exempt salary where you're guaranteeing an employee a set amount of money per week. But if they work less, they're going to get that amount. However, you still have to have them track their time, and they still would be entitled to overtime 4 hours over if it's Virginia and federal over 40 in a week. If you have a state that has a daily overtime, they would be entitled to that as well. So sometimes employers like to do the non-exempt salary because it's great for team morale. Sometimes people view hourly as kind of like lower level, and it disappoints them. So guaranteeing that, but then you still have all of the burden of tracking time. So a lot of employers don't feel like it's worth the extra effort to not get the benefit of reducing pay if someone works less time.
Yeah, thank you. Next question is, could you clarify that point about complying with nationwide pay transparency depending on your posting? Isn't it the case with most ATS that you could apply to anyone's job on the internet? For example, my company only really looks to hire people in Virginia, but I think anyone on the internet could find our jobs page and put in an application.
Great question. So if you are intending for the role to be in Virginia, you can just post based on the Virginia requirements. If you're opening it up that, yes, usually most of our employees are in Virginia, but we're open to hiring a remote employee anywhere, then you would have to follow those requirements. If you're open to relocating someone and they're going to be in Virginia, again, you can follow the Virginia requirements. It really is just the employers who are like, we don't care where the employees are, they can be in any state. That's when you need to make sure that you're following those requirements.
Okay. And the last question we received, does minimum wage threshold also apply then to remote workers? For example, a position is budgeted for $55,000 salary annually, but the remote employee lives in another state where the minimum wage is higher than $55,000.
So wherever the employee is performing the work is the minimum wage threshold that you need to follow. So if they're in Washington State, we said it was a little over 80,000 and they're a salary exempt role, they would need to meet that salary exempt threshold, even if you're budgeting and you were originally planning to hire someone in a state that has a lower threshold. So you would need to make it meet that threshold, or they would need to be hourly.
Perfect. And I got a few extra questions here. I know that we have a couple more minutes, so I want to make sure that we get these last two that came in. Does the sick/vacation day accrual rate have to be equivalent to what an employee would work normally?
Does the sick uh, so let's use California as an example. If you have sick time, you have to either give a flat amount of hours at the beginning of the year, or you have to accrue 1 hour for every 30 hours worked. If you're giving a flat amount, you have to give that amount the same to anyone, whether they work 5 hours a week, 40 hours a week. You cannot prorate that front-loaded amount based on the hours that that person works. However, if you're doing an accrual, like 1 hour for every 30, it will just accrue based on the number of hours worked. So if someone works 15 hours per week, it's going to take them 2 weeks to accrue 1 hour, and so forth. So it can depend depending on if you're doing an accrual or front loading. But front loading, typically, most states, you cannot prorate.
And last question here is, could you explain a little bit more about the notification and posting requirements to let employees or applicants know that we participate in E-Verify?
So just in I believe you're just saying in a job description. So you can just include a little line about how, we participate in E-Verify, and that will need to be completed prior to employment, and verify I-9 documents. When you're enrolled in E-Verify, you still need to complete an I-9 for all of your employees, so it doesn't substitute, it's just in addition to. We can get some language and send that out with the recording if that works with you, Ash.
That's perfect. I think that covered it. And so I think that's all the questions. Let me just check to make sure that I have all of those, and I think that I do. And so I just want to say thank you all so much for joining us today and taking the time to be part of this conversation. I hope the insights that we covered help you feel more confident and prepared as you navigate your HR compliance as we head into the year ahead. We appreciate your time, and we hope that you have a great rest of your afternoon. Bye, everyone. Thank you again, Susan.
Thank you.